signature of defendant Melvin Kinsey. I'll hold that up to the camera. Can you see that? It's your signature there? And when did you sign this document, Mr. McKenzie? All right. And was your attorney there to explain everything to you and answer any questions you had about it? And when you signed it, did you understand that it's agreement to plead guilty, which means there won't be a trial, and the next step in your case will be a sentencing hearing? Okay, perfect. All right, well, we just gotta be patient, gotta go through the process here, okay? So you understood it was agreement to plead guilty. All right. And did you feel you had enough time to fully consider this matter before you made that decision? You don't feel that you were rushed or pressured in any way in doing this? And you're entering into the agreement to plead guilty voluntarily, Mr. McKenzie? All right, now the agreement states on page 1 that you're going to withdraw your not guilty plea, plead guilty to counts 1 and 3. Count 1 is aggravated trafficking methamphetamine. Count 3 is aggravated trafficking methamphetamine consenting juvenile. Both of those would be in violation of section 2925.03A1 of the Ohio Revised Code. Count 1 is a fourth degree felony, and count 3 is a third degree felony. Now, page 1, it says that you understand that if convicted, the maximum possible prison term for count 1 is 18 months. Minimum will be 6 if the prison term proposed. You find $5,000 and a license suspension 6 months to 5 years. Count 3 states that the maximum state prison term is 36 months. The minimum will be 9. There's a fine available of $10,000, a mandatory fine of $5,000, and a license suspension 6 months to 5 years. You understand that? Now, in the event that you are convicted of both of these offenses and sentenced to prison, the sentences could be ordered to be served consecutively, meaning one after the other. So if you add up the worst possible scenario, 18 months to count 1, 36 to count 3, that's 54 months, maximum fine $15,000. You understand that? Well, you can't guess. Either you do or you don't. Okay. Now, are you facing any felony charges anywhere else? Okay. Are you on probation, community control, parole, or post-release control for a felony from any county other than Lima County? Okay. Now, under the law, Mr. McKenzie, if you are convicted of this offense and sentenced to prison, then upon completion of that prison term, it is possible the adult parole authority could exercise the option under the law to put you under what's called post-release control supervision for a period of up to 2 years. If they did that, you would be supervised on the terms that they set by a parole officer, and if they determined that you failed to comply, then upon that finding, they could return you to prison, make you serve an additional period of up to 9 months for one violation of a maximum of half of the prison term for all violations. But if your violation were a new felony, then in addition to whatever sentence the judge in the new case would impose upon you, that judge could also sentence you for committing that offense while under post-release control in this case, for an additional period of 1 year, whatever time's left on that period of post-release control, whichever is greater. If that occurred, that would have to be served consecutively with sentence in the new case. You understand that? All right, now, under the law, I'm not required to sentence you to prison for this offense. I can impose what's called community control or probation. What that means is instead of being sent to prison, you would be put under supervision of a probation officer in this county under the terms set by the court for up to 5 years. And if during that period of time they felt you were not complying, then they would file a written notice to that court, serve a copy on you, and there would then be a hearing, and you would have an attorney. If the outcome of that hearing was to fail to comply, then at that time the court could revoke community control and then send you to prison for 54 months and fine you $15,000. You understand that? All right, is that? Pardon me? Yeah, that's what the proposal is. Okay. All right. Now, Mr. McKenzie, one thing I didn't forget to say at the beginning of the hearing is that since we're not in the courtroom sitting next to your attorney, at any time you want to talk to him about it, then you tell me. I can put the two of you in a breakout room or just you and him on the screen talking. No one else will be able to see you here. Okay? All right. Now, the charge in count 1 alleges that on or about March 25, 2021, in Hyden County, Ohio, Carl Eugene Hatfield and you did knowingly sell or offer to sell methamphetamine, to controlled substance, violation section 2925.0381. And that is the charge of aggravated traffic methamphetamine, fourth degree felony, possible 6 to 18 month sentence, and a fine of $5,000. Count 3 alleges on or about May 28, 2021, Hyden County, Ohio, Carl Eugene Hatfield and you did knowingly sell or offer to sell methamphetamine, schedule 2 controlled substance, and consenting to juvenile, in violation of 2925.0381, and that's the that's the fourth degree felony. The other one, can't remember what that's third degree felony, yeah. That carries responsible prison term between 9 and 36 months in increments provided by law. They fine $10,000, mandatory fine $5,000. Both of them have license suspension of 6 months and 5 years. Awesome. Now, Mr. Kenzie, do you understand what you've been charged with in each of those counts, what the state said you did, when, where, and how they alleged you did it? That's what it's alleged, yeah. So you understand what they're saying? Okay. All right. And you understand the possible penalty? Okay. Now, have you discussed the nature of those charges, the evidence in the case, possible legal issues in the case, possible defenses you might try to raise at a trial, possible outcomes of a trial with your attorney? Yeah. Are you satisfied with this? Yeah, that's nobody should. Yeah, just answer my questions, okay? So, have you discussed everything with him? And okay, and are you satisfied with his advice and confidence in this matter? Well, we'll get to that in a minute. But my question is, are you satisfied with him, his advice and confidence in this matter? All right. Now, are you under the influence of any types of drugs or alcohol at this time? You're not taking any prescription drugs? Right? Has anyone threatened you to make you plead guilty here today? Now, the agreement that you've been talking about, we'll get to now, the last 4 lines are printed in bold and underlined on page 2, read as follows. Defendant owner plead guilty to counts 1 and 3. State will dismiss the remaining counts. State defense joint will recommend 9 months on count 1, consecutive 12 months on count 3. Defendant shall pay restitution in full and cooperate fully with the task force, including testimony against the defendant. Is that your understanding of the agreement? All right. Okay, well, restitution is what we're talking about there, not court costs. But I just read you the agreement, so I'm hearing that that's not your understanding of the agreement. So, you want to talk to him, Mr. Kirk, breakout room?
Yes, I can. I believe he's confused. I think when he hears work, he means be employed by or do something like that. So if he needs me to clarify that, we can be breakout room.
All right, let's do that, because right now he's saying that's not his understanding of the agreement.
Yeah, I think there's some.
All right, I'm going to put you in a breakout room, and there's going to be a button that's going to come up that says join the breakout room, and when it does, you click on that, and when you and Mr. Kirk, are done talking, it'll say leave breakout room, and you push on that button, the deputy's going to step out of the room and talk to your attorney alone. And that should be opening up here shortly. Ms. Witch, you may want to run that agreement over now, because I think it's going to be a few minutes, this case and this Sacker's case, and it should give you time to get over here and get back. That way we'll have to wait for you to get over here. Or to do it, because you're going to have 2 cases back to back, and I don't want to have pull up this cell logo, okay? All right, defendant, Mr. Kirk, has returned. All right, Mr. Kirk, have we cleared up any issues there?
Yes, I did so.
Okay, so Mr. Kenzie, then you understand the agreement as to what that meant after your discussion with Mr. Kirk? Okay. Now, under the law, Mr. McKenzie, the matter of the sentence is up to the judge, not to the parties. The prosecutor is recommending, along with your attorney, that you be sentenced to 21 months total of the 54 as possible. Now, the law, the actual decision, the amount of time is up to the judge. So, if you plead guilty, I could follow the recommendation, or I could decide that that's not the correct sentence. I can propose a different sentence, including prison as much as 54 months, fine, and license suspension. You understand that? All right. Now, you have certain constitutional rights to understand before I accept the plea from you. But let me back up. You hold any kind of license or certification from any state agency that regulates any profession or occupation. All right. Now, you have certain constitutional rights to understand before I can accept guilty. First, you have a right to have an attorney. Mr. Kirk is appointed representation that I wasn't sent to work the case out and provide whatever defense may be able to under the law which you wish to provide. So if you decide you do not want to do this, you will still be represented by counsel, she'll defend you, including in trial, if that's what you want. You understand that? All right, under the Constitution, you have the right to have a jury trial in this matter, in which 12 people would be selected from a group of people that live in Hyde County that are summoned for jury duty under your trial day. After they're selected, they have to be presented and be instructed on the law. And then that jury would have to decide by unanimous verdict as to each count, meaning that all 12 of them have to agree on a verdict in each count in order to find you guilty or not. Now, if you decided that you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means you give up your right to have a jury trial, and in that case, you would have what's called a bench court trial, meaning the judge would be the one to hear the evidence instead of the jury. Judgment by the law, the judge would decide whether or not to state truth or guilt by proving beyond reason doubt on either of the two counts. You understand that? Now, under the Constitution, you have a right to confront witnesses against you to cross-examine through your attorney. What that means is the witness against you has to come into court testifying from you, your attorney, and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions, that's called cross-examination. The purpose of that is trying to bring out evidence to help your side of the case. You understand that? Sure, my allergies are acting up. All right, now in the Constitution, you have a right to confront the witnesses against you in open court and cross-examine them through your attorney. What that means The witnesses against you have to come into court, testify in front of you, and your attorney, and anyone else is present. After the prosecutor's done asking those witnesses questions, your attorney asks questions, that's called cross-examination. And the purpose of that is to try to bring out evidence that helps your side of the case. You understand that? Now, under the Constitution, you have the right to use the power of the court, bail or force witnesses to come into court to testify on your behalf in the same state. So if you have witnesses you're not certain going to come in and testify voluntarily, that's your request for issues of court order, that's a subpoena, and that forces those people to come to court, be able to testify if they want to, even though they don't want to be here, which is the same way the state witnesses are required to come to court. You understand that? And under the Constitution, you have privilege against self-incrimination, which means you're not forced to give evidence in this matter at any time, including trial. No one can ever make a testify. The prosecutor can't, the judge can't, you make that decision. You can decide not to testify. The fact that you did not testify not be used against you in any way by any person at any time. No one's even allowed to comment about it except for one situation, which is if there's a jury trial and you don't testify, the judge will trust the jury that because that's your right to not consider it for any purpose. You understand that? Alright, now in the Constitution, you have the privilege against self-incrimination, which means you cannot be forced to give evidence in this matter. I think I just covered that. Well, I'm going to. You cannot be forced to give evidence against yourself at any time, including trial. No one can ever make a testify. The prosecutor can't, the judge can't. You make that decision. If you don't testify, the fact that you did not testify cannot be used against you in any way, any person, any time, except in the case of jury trial, which if you do not testify, the judge trusts the jury that because that's your right, they cannot consider it for any purpose. You understand that? Under the Constitution, Mr. McKenzie, you have a presumption of innocence, which means that it is a burden upon the state to prove your guilt by proof beyond a reasonable doubt every essential element of each offense. So it's not, the burden's not on you to try to prove you're not guilty simply because you've been accused. In fact, for the law, you don't have to present any defense at all. You may, but you're not required to. Whether you do or not, the burden of proof will be always on the state to prove your guilt, proof beyond a reasonable doubt, every essential element of each offense by proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. You understand that? Alright, now, originally you pled not guilty, guilty plea, or not guilty plea, denied the allegations in the indictment, denied you committed a crime, and exercised or invoked all the rights I've just described. Now, you change your plea today from not guilty to guilty of counts 1 and 3. That's the opposite of not guilty. Guilty plea will admit the allegations in each count, admit that they constitute a crime, that you committed that crime, and that plea is waived or give up all the rights I've described for you today, except the right to have an attorney. Always have a right to your attorney no matter what your plea is, with that exception. Plea of guilty is waived or give up the right to a jury or court trial, waived or give up the right to confront witnesses and cross-examine your attorney, waived or give up the right to use the power of the court to compel or force witnesses to come to court to testify to be the same as the state. We give up the privilege of self-incrimination, because if you say you're guilty, that's what you find guilty. The way to give up the presumption of innocence, because if you say you're guilty, say that that's true. We also suggest you be sentenced immediately by the court. And then finally, waive gives up any right to file an appeal that you think you may have for this point of the case. Now, if you are sentenced to the maximum sentence under certain circumstances, you can file an appeal and have to file for 30 days for sentencing after you file. You understand all that? Alright, now, and you are a U.S. citizen, Mr. McKenzie? Now, do you have any questions about the charge or the possible penalty on either of the first or third counts? Okay, you understand it? Have any questions about the plea agreement? You understand it? You have any questions about it? Okay. Do you have any questions about the constitutional rights I've explained to you? You understand those? Have any questions about the plea of guilty, what it means, what will happen again on that plea here today? You understand? Anything else you'd like to speak to the attorney about before we go any further? Do you have any questions that you would like to ask me about anything I've explained to you today? Okay. Then is it your decision to go ahead and plead guilty to count 1 and 3 according to the plea agreement we just went over? And as to count 1, which alleges on or about March 25, 2021, Huntington County, Ohio, Carl Eugene Hatfield and you did knowingly sell or offer methamphetamine and Schedule 2 controlled substance. Violation of Section 2925.0381, charged with aggravated trafficking methamphetamine, fourth degree felony, carrying possible prison term between 6 and 18 months, fine $5,000, a license suspension 6 months, 5 years out of the plea. As to count 3, which alleged on or about May 28, 2021, Highland County, Ohio, Carl Eugene Hatfield used to knowingly sell or offer to sell methamphetamine schedule 2 controlled substance in the city of Greenville. Violation section 29.5.131. A third degree felony carrying possible prison term between 9 and 36 months, fine of up to $10,000, mandatory fine of $5,000, and a fine of license suspension 6 months, 5 years under plea. Alright. Court finds on this day open court, defendant was advised of all his constitutional rights. They did only tell the voluntary way of abstaining from September 11th. Please accept it for 5. Defendant found guilty of count 1. Count 3 is charged therein. Counts 2 and 4 to 6 are dismissed as to this defendant. The court orders those pleas to be filed and findings of guilty entered. Now, based on the fact that Mr. McKenzie's got a previous record and there's a joint recommendation of sentencing, or not order a percent investigation, not questionable either. And so I'll go ahead and proceed with sentencing. Alright, Ms. Collins, on behalf of the state.
Your Honor, for that, $300. We settled on that with the Highland Task Force, and just wanted to ensure that he understands that he is required to cooperate with the task force.
Is there any question about that, Mr. Burke?
And I believe he was under the impression he could act when on the street line through so that's not what they mean. It was cooperation in any case.
Right. You understand that, Mr. McKenzie? Okay. All right. Mr. Kirk, anything you'd like to say?
Thank you. I would ask for a public hearing of my understanding that was a practice in the case of so it's for you can also ask for
McKenzie, anything you'd like to say? You're not required to say anything, but I'll hear whatever you'd like to say. Alright. Then it's the judgment of the court that defendant B is hereby sentenced on count 1 to a term of 9 months at the Correctional Central Center in Warren, Ohio, and on count 3 to a period of 12 months at the same facility. It's ordered that those sentences be served consecutively to one another for a total of 21 months. The court finds that the second sentences are appropriate because there's been a stipulation to that. The court finds that these evidence two are courses of conduct and that one single prison term not actually reflect the seriousness of the offense, and the harm caused is not disproportionate to the severity of the sentence. And also the defendant's prior criminal history justifies the imposition of the second sentence for possession of the phone. The defendant is arrested on April the 8th, Mr. McKenzie. Okay. April 4th, where are we arrested? Okay, well, they only have you down, they have you down to be arrested on April the 8th. You weren't indicted on April the 5th, so you weren't arrested on April 4th.
No, it was April 8th.
No, it wasn't the 4th because you weren't indicted for that day unless you were arrested on something else. But you were arrested according to this. They didn't receive warrants on the 8th of, well, they received it on the 5th, and the return says you were arrested on the 8th. So, April the 8th it is, that's 54 days to go find credit. Now, upon completion of this sentence, Mr. McKenzie, it is possible that the Electoral Authority may exercise the option that they have under the law, which are under post-release control, for a period of up to 2 years, and if they do, you'll be supervised on the terms they set by a parole officer, and if they determine you fail to comply, the returning to prison may serve an additional period of 9 months for one violation, up to a maximum of 10.5 months, which is half of 21 months for all violations. However, if you commit a felony on post-release control supervision, then an additional sentence judge in new case proposed by the The judge is also authorized to sentence you to an additional period of 1 year or whatever time is left on the post-release control, whichever is greater. That occurs and as we serve consecutive sentences in the case. You're also ordered to pay $300 restitution directly to several of the co-defendant and payable once you're released from prison to the victim witness restitution account, and you pay service fees associated with that. There'll be no driving suspension, and the court finds Mr. McKenzie's circumstances were such that he will not likely be paid a mandatory fine now or in the future, so that is waived. All right, so anything further from counsel? Okay. All right, thank you. All right, we need Joseph Michael McClure next, please. All right, are you Joseph Michael McClure appearing there from the jail? All right, this case number 22 CR 100, State of Ohio versus Joseph Michael McClure. This hearing being conducted by Zoom. It's a pre-trial, first on pre-trial, trial set for June 27th. Mr. McClure is very from the jail. His attorney is Captain Hatner, her office with Zoom, and appearing from the prosecutor's office and prosecutor's attorney office. Defendant charged with rape for sexual position. Now, looks like all discovery has been provided, and at least we state that you, well, have you provided all your discovery as well?
Yeah, like discovery not provided.
Right. And don't see any compliance from the fence yet, Ms. Hacker. Right.
Yes, she has been filed on May 13th.
The fence was on, okay.
We went over this in the last. She couldn't find it, she didn't know she filed it, but I have filed it on May 13th.
Well, it's still not in the file. One of you would be, oh no, here it is, it's out of order. It's after May 19th. Silly me, I thought it would be chronological order. Anyway, that must be a problem. I'm going to take this out and fix that myself. All right, now, been no pre-trial motion filed?
There is not, Your Honor. I still need the discussion with my client, and I'm anticipating further discussions with the state court.
Okay. All right, is there anything further that to come forward the court at this time? All right, then, I'll let you hear from counsel this one off. Okay. All right, Aaron Neal, please. Well, actually, keep your setback, but I guess I'll take that. All right. Purcell.
Purcell.
Well, let's go ahead and do this for Sal since she's there. Case number 22-CR75. State of Ohio versus Clarissa Frankie Del Purcell. Present, she is appearing by Zoom from. Okay, she is appearing, defendant's appearing by Zoom from treatment facility. Her attorney is with, appearing by Zoom, also appearing by Zoom from the prosecutor's office, prosecutor Collins. Defendant is charged with one count of aggravated possession of felony with the felony. And this matter is set for final pre-trial. And I've been pleaded guilty for. First of all, Ms. Witt, do you and your client both stipulate that her appearing remotely by video today rather than in person appearance?
Yes, we do.
You're agreeable with that, Ms. Purcell?
Yes, Your Honor.
All right, defendant's charged with aggravated possession of aggravated felony. And I've been presented with a plea guilty form. I'll hold that up to the camera. Do you recognize that form has your name, case number, plead guilty, said plead guilty to the charge?
Yes, Your Honor.
All right, page 3, there are signature lines, and about a third of the way down on page 3, there's a sentence that says that was plea voluntarily. Right below that, there is a signature, and that this may be a copy, because the others are blue. Is that any copy of your signature there on that document?
Yes, Your Honor.
You recognize that when it's signed?
Yes, just right before we started.
All right, then you pass it to Ms. Witt for her to sign, get the prosecutor sign. Okay. Now, when you sign this document, well, before you sign it, have you talked to Ms. Witt, gone over it, and explained it, and taken any questions?
Yes, sir.
And you understood this agreement, plead guilty, the case won't be a trial, next step, the case will be sent to the hearing.
Yes, sir.
And did you have enough time to fully consider this matter before making this decision?
Yes, sir.
Do you feel that you've been pushed or rushed in any way in doing this?
No.
And are you entering into the agreement to plead guilty voluntarily?
Yes.
Now, the agreement states on page 1 that you are going to withdraw your non-guilty plead guilty to the charge under 4925.11 RIS Code 53 felony. Takes you to understand that the maximum state prison term for that would be 12 months, minimum would be 6. There would be a fine available of $2,500 and a possible license suspension 6 months to 5 years. You understand that?
Yes, sir.
Are you facing any felony charges anywhere else?
No, Your Honor.
Other than that?
No.
Okay. And other than that charge, are you on probation, community control, parole, or post-release control of any jurisdiction?
No, Your Honor.
All right. Now, under the law, if you are convicted of this offense, and should be sent to prison, once that prison term is complete, the adult parole authority may exercise the option they have under law, put you under post-release control supervision for a period of up to 2 years, on the terms they set. If they determine during that period of time you fail to comply, they can return you to prison, make you serve an additional period up to, in this case, half of your prison term for one or more violations. However, if you've been a felony under post-release control, then in addition, whenever sentence the judge in education imposed upon you, the judge will also sentence you to an additional period of 1 year or not that on that post-release control generally greater. If that occurs, that has to be served secondly the sentence in the case. Understand that? All right. Now, under the law, not required to sentence you to prison, can impose a community control sentence, which means instead of going to prison, you can put under supervision of the probation office under the terms that they set, or set by court, for a period of 5 years. And then during that period of time, the probation department will not comply. They could return you to prison, make a short additional period. They could file a notice of that with the court, give you a copy. There will be a hearing, and you could be represented by an attorney at that time. And if the outcome of that hearing was to comply, then the court would revoke community control and then send you to prison for 12 months, fine, $2,500. You understand that?
Yes, Your Honor.
And under the documents you're charged with, it reads that on or about August 10, 2021, Huntington, Ohio, you did not only obtain, possess, or use, or schedule 2 controlled substances with methamphetamine in violation of section 2925.11 of the revised code, which is again a 5th degree felony. Do you understand what it is you've been charged with in that The document the state said you did, we weren't how it alleged you did.
Yes, sir.
You discuss the nature of the charge, the evidence of the case, possible legal issues of the case, possible, penalties might try to raise for possible property attorney.
Yes.
Are you satisfied with your advice and confidence in this matter?
Yes.
Are you under the influence of any type of drugs or alcohol at this time?
No, Your Honor.
Are you taking any prescription drugs?
I'm prescribed Prozac.
Okay, does that interfere with your ability to understand what's going on, what you're hearing and communicating? Have any threat made against you plead guilty here today? Page 2, there are a couple of lines that are printed in bold, read as follows. Defense shall not plead guilty to indictment, state defense shall not recommend you control mission drug. Has anyone promised you anything other than that against you plead guilty here today?
No, Your Honor.
All right, now, you have certain constitutional rights to understand before we, before I accept the plea. First of all, you have to break that counsel. This witness appointed represents you not simply to work the case out, but to provide any defense that would be available to you under the law that you wish her to provide. So, if you decide you do not want to do this, if you would rather defend the charge and have her continue to represent you, then she would represent you including the trial if that's what you want. You understand that?
Yes.
Right now, under the law, we have our right to have a jury trial in this case, which 12 people will be selected from a group of Pine County residents, telling the jury you have your trial. They have to be selected, they have to be presented, they be instructed on the law, and then they would decide by unanimous verdict, all 12 of them have to agree as what the state jury is guilty. Now, if you decided you didn't want to have a jury trial, you didn't want to be guilty, you can waive the right which means you give up, right to have a jury trial. And in that case, you would have to call a court defense trial, meaning that the judge would be the one to hear the evidence instead of the jury. Judge would apply the law, and the judge would decide whether or not state prove your guilty or penalty for that. You understand that?
Yes, sir.
Right, under the Constitution, you have a right to use proper court, tell a court witnesses coming forward to testify on your behalf and send to state. What that means is if you have any witnesses, you're not certain whether they're voluntarily request court issues a court orders to subpoena, and that forces the witnesses to come forward, be able to testify and want them to. Even though they don't want to be here, it's the same way the state was forced on the court. You understand that?
Yes, sir.
Under the Constitution, you have a right to confront witnesses and issue in open court and have your attorney cross-examine, which means witnesses against you have to go into court and testify in front of you, your attorney, and will also be present. After the prosecutor is done asking questions, your attorney will ask questions, that's called cross-examination. The purpose of that is try to bring out evidence to help your side of the case. You understand that?
Yes, sir.
Right, under the Constitution, you have a privilege of self-determination, which means you're not be forced to give evidence in this matter at any time, including the trial. Only the government can testify. The prosecutor can, the judge can, you make that decision. If you decide not to testify, the fact that you did not testify, now you can issue it anyway with any person, only need to comment on it, except in the situation that is, if there's a jury trial, you don't testify. The judge instructs the jury that because that is right, not consider it for any purpose. You understand that?
Yes, sir.
Right now, under the Constitution, we're presumed innocent to prove guilty by the state of Ohio ever since filed of the defense charge. What that means is the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused. In fact, I'm wrong. You don't have to present any evidence in your defense. You may, you're not required to, whether you do or not. The burden of proof will remain on the state to prove your guilt and prove beyond reasonable doubt, which is the highest burden of proof is known under the law. You understand that?
Yes, sir.
Right now, originally entered plea not guilty, was denied the allegation of the indictment, denied committing the crime, and exercised all the rights after the distraction. Now, if you change your plea from not guilty to guilty, that is the opposite of not guilty to guilty. You admit the allegations, admit their crime, but you won't commit that crime. That plea, waive give up all the rights after distraction, except for right hand attorney, which you always have no matter what you plead. That exception, plead guilty, waive give up the right to a jury court trial, waive give up the right to confidence, issue cross-examine attorney, waive give up the right to use power of court, compel a court to speak or to be the same as the state, waive give up for proving yourself determination because you can be saying you're guilty, that you find you guilty, waive give up your presumption of innocence because if you say you're guilty, the state's not required to prove you guilty. It also subjects you to being sentenced immediately by the court, and finally, waive gives up right now, appeal, we think they had up to this point in the case. Now, if you should change your plea to not guilty, that's the opposite of not guilty plea. And that would break all of those rights and don't make any sense. We propose that we should for today. Now, it also ways that it gives up their right to appeal if they have, other than, like you said, potential back and back. You understand all that?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
Do you have any questions about the charge, possible penalty?
Yes, sir.
Understand?
Yeah.
Any questions about the plea agreement?
No.
Understand it?
Yes, sir.
Any questions about the constitutional rights of the claim?
Yes, sir.
Understand those?
Yes.
Any questions about the plea of guilty, what it means, what consequences that means for that plea agreement?
No.
Understand?
Yes.
So anything you'd like to speak to Ms. Wood about before we go any further, or so I can push your break out?
No, I spoke for.
You have any questions at all?
Yes, sir.
This is your decision to withdraw not guilty plea, plead guilty to the charge of count one, pursuant to this agreement.
Yes.
Then after the charge was alleged on or about August 10, 2021, Highland County, Ohio, you did knowingly obtain, possess, or use Schedule 2 controlled substance for methamphetamine, violation section 2925 of the Ohio Revised Code, a 5th-degree felony, carrying possible prison term from 6 to 12 months, fine $25, mandatory license suspension 6 months, 5 years after plea.
Guilty.
Alright, court finding on this date of court, defendant applies all the constitutional rights and employment of the voluntary waiver for saying, pursuant to Rule 11, please accept the 45 defendant and found guilty of charge. Set over there. I see that there's a request for pre-sentence report, but I'm saying that's the she's in drug court, and so I'm going to go ahead and proceed with sentencing report. Unless the parties wish to have an updated BSI. Ms. Witt, do you wish to have one?
Any other screen?
Ms. Collins?
No, you're,
Alright, anything from the state regarding sentencing?
other than the standard of the agreement, you would know that, the reason I'm making the recommendation for drug court is because this one actually occurred for the branch department of drug court.
So, Whit, anything you'd like to say?
Sure, we do have some critical of the trigger aggregation, special teaching the drug court, so you're taking usually 12 areas, and some of those are very stated discharge that happened, previous to, or, recent drug court.
Okay. Mr. Purcell, anything that you would like to say?
No.
Alright. Well, I know you have been in drug court, and I think you've been progressing, reasonably well. And, it is your desire to be in drug court in this case as well?
Yes, Your Honor.
Alright. The court then will, grant entry, into the drug court docket on this case. And, will order you to, the court is to be placed under, community control on the drug court docket on the same conditions as you're currently, under for a period of 3 years. And, in the event that, there will be no fine out or, suspension of driver's license, by the way. But in the event that, you fail to comply with those conditions, then the, probation department will file a written notice back to the court. There will be a hearing, and have an attorney represent you. And the outcome of that attorney, or of that hearing is that you have failed to comply. Then, at that time, the court will go control and terminate you from drug court and send you to prison for a period of 12 months and $25,000. That occurs, and also subject to be placed under post-release control for a period of up to 2 years. And if the Dr. Board found that you had failed to comply, they can return you to prison for an additional period of up to 9 months on one violation, up to go back after the prison term for all violations. However, if you felony, then in addition, whatever sentence the judge in the new court, in the new case, you propose that it is also sentenced to an additional period of 1 year where the time is up on the 2 years of post-release control whatever greater that occurs, and must be served secondly, the sentence in the case. And you overpay the court costs, as well, again, I'm not going to go over everything else, but it's the same, all conditions are the same as you're currently having. All right, is there anything, further from council?
Mayor,
All right, thank you, so.
Your Honor.
Yeah, you're good, you go ahead and sign off.
Okay.
Alright.
Okay, thank you.
Alright, and are you ready to kneel there at the jail? Alright, we have, 2 cases here, all with the, same defendant, both David Ohio versus Eric Neal. Case number 22-CR-114 and 22-CR-115. This hearing will be that presumed pretrial. Mayor of State is prosecutor Clarence Collins, and let's see, Ms. Wood, you represent Mr. Neal as well?
yes.
Yeah. Mr. All right, now in case number 114, Mr. Neal was charged with conspiracy and everything theft and a forfeiture, and in case number 22-CR-115, he's charged along with the co-defendant. He's actually charged with 8 counts of miscellaneous aggravated trafficking and possession of drugs. All right, now, let's see. I have a question. Discovery looks like the state filed for particular discovery last week, and in that case, and just live here to see. This is the first free trial we've been in. Your final, okay, so we started to do final free trial. You anticipate the free trial motions at this point?
Yes.
Okay. Has been written over by
Yes, there
your time wherever yet.
is.
All right. Now, case number 22-CR-115, which was just indicted last month. Second State had provided the bill of particulars and discovery, so you do see that this way. Discovery you do by final free trial, and anticipate the free trial motions in that case,
Yes.
and they all were received on it.
Yes.
Matters that we can discuss it further this time in this case.
Yes.
All right, we'll see you next free trial, sir. Neil, I'm sure you're trying to get that. Thank you. All right, Cheryl Hendrick. Senator, who do you have that's left on Zoom? I don't have you down for any further Zoom here. Would that be Mr. Green?
No, you saw that question.
Oh,
He's in
all
there.
right.
He should be.
No, yeah, he was removed by this morning, so apparently nobody told you he's not on my dock. So looks like you're done with the Zoom doc. I think you have Mr. Wilson over here. Yeah, okay. So you're good. All right, thanks. You know, it was not, the problem is that the clerk doesn't move those off the docket when that happens, and it turns out that way. And then this morning, staff caught it, we were busy, apparently, that time we always apologize for that. You're good too. Yeah, you have a line art, Mr. Green. Yeah. All right, thank you. All right, are you sure I had Peter? Am I pronouncing that correctly, Peter? Hendrick, okay, sorry. Case number 22-CR-119. Ms. Hendrick is appearing by Zoom to the Justice Center. our attorney is Daniel Witt, appearing by Zoom, and appearing in the prosecutor's office by Zoom is Prosecutor Collins. Defendant is charged with aggravated traffic methamphetamine and aggravated possession. And I do have a proposed plea of guilty for him here. Now, Ms. Witt, do you and your client both agree to waive her physical presence in the courtroom and agree that the plea will proceed by remote hearing using Zoom? You're all right with that, Ms. Hedrick? Okay. Now, I'm holding the form of guilty in my hands. I'll hold that up to the camera. That's your case number, your guilty charge there. See that? And on page 3, there are signature lines on this form, and about quite halfway down the page, there's a sentence that reads, I enter the plea voluntarily. Immediately below that is the signature, which appears to be the signature of Cheryl Hedrick. Is that your signature holding up there? When did you sign this agreement, Ms. Hedrick? When did you sign the agreement? And did your attorney go over with you there at jail, explain everything to you before you signed it? When you signed it, did you understand this agreement to plead guilty, which means there's not going to be a trial, and the next step in your case will be a sentencing hearing? And do you feel you have enough time to fully consider this matter before making this decision? And are you entering into the agreement to plead guilty voluntarily? Right, it says on the first page, you're going to withdraw your non-guilty plea, plead guilty to charge. Count 1 of aggravated aggravated trafficking in methamphetamine. Further, in violation of section 2925.0381, a third-degree felony. Further states that you understand that the maximum penalty for that, if you're convicted, could be 36 months in prison, with a minimum of 9 months in prison term imposed. There's a fine available of up to $10,000, and a court fine of $5,000, and a license suspension is possible of 6 months to 5 years. You understand that? Now, the law says that there's a presumption of prison on the imposed for this offense, but it's not required. So, if you plead guilty, I still make the decision whether you should go to prison. You understand that? Facing any felony charges anywhere else? Are you currently on community control, probation, parole, or post-release control from any jurisdiction? Under the law, if you're convicted of this offense and sentenced to prison, once you complete the prison term imposed by the court, the adult parole authority may exercise the option under the law to put you in post-release control for a period of about 2 years. If they do exercise that option, you'll be supervised by a parole officer on the terms they set, and if they determine that you have failed to comply during that period of time, they could return you to prison and you serve an additional period of up to 9 months in a single violation. There is a cap limit, half of whatever prison term is imposed for all violations. However, if you're convicted of a new felony while in post-release control, then an additional whatever sentence can be imposed by the judge in the new case. That judge will also be authorized to sentence in this case to an additional period of 1 year or whatever time left on the post-release control time, whichever is greater. If that occurs, that has to be served consecutively with the sentence in the new case. You understand that? Under the law, not required to sentence you to prison, as I indicated, there's a presumption that it's not mandatory. So I could decide that rather than sentence you to prison, you would put under supervision of the probation department for a period of up to 5 years as a term set by the court. If during that period of time, the probation department felt that you're not compliant, they would file a written notice at the court. There would be a copy given to you. There would be a hearing, and if the outcome of that hearing was that you failed to comply, then at that time, the court would revoke the control and then sentence you to 36 months and probably $10,000. You understand that? Right. Now, the charge in count 1 alleges that on or about June 17, 2021, Piney County, Ohio, you did knowingly sell or offer to sell methamphetamine at Schedule 2 controlled substance amount equal to or exceeding bulk amount less than 5 times the bulk amount. Violation of section 2925.0381, Ohio Vice Code, a third-degree felony with the possible prison term between 136 months, fine of $10,000, mandatory fine of $5,000, and a license suspension of 26 months to 5 years. Now, Henry, you understand what it is you've been charged with the state said you did when we were out of the Discuss the nature of the charge, evidence in the case, possible legal issues, case, possible offenses might be tried to raise for trial, possible trial with attorney. Are you satisfied with third license conflicts in this matter? Are you under the influence of any types of drugs or alcohol at this time? Are you taking any prescription drugs that interfere with your ability to understand what's going on and communicate? Have any threat made to make you plead guilty here today? Now, on page 2, there were 4 lines that are printed in bold and underlined, and then one sentence of that has been stricken out to indicate it does not apply. So I'll read the remaining portion as follows. Defendant shall enter plead guilty to count 1, state will dismiss count 2, state defense will argue sentencing, then agree to pay back fine money to the Hunt County Task Force in the amount of $160, then agrees to cooperate fully with the task force. That's your understanding of the agreement? You don't promise anything other than that in case you plead guilty today. You're not going to promise that if you plead guilty, you're going to get anything for Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession? You have certain constitutional rights, let's understand. For our conception of pleading guilty, first you have right to counsel, and this witness appointed representative should not simply work the case out, but provide any defense that can be available to you under the law which you want her to provide. So, if you decide you don't want to do this, you want to defend the charge, to continue to represent you, including a trial, that's what you want. Understand that? Under the Constitution, you have a right to have a jury trial in this matter, in which 12 people will be selected from a group of citizens who live in this county, summoned for jury duty at your trial. After they are selected, the evidence will be presented, they will be instructed on the law, and then that jury will decide, by the end of the verdict, between all 12 of them have to agree, as to whether the court or the state proved your guilt of the charge. Now, if you decided you didn't want to plead guilty, but you didn't want to have a jury trial, you can waive your right, which means give up, right to have a jury trial. In that case, that's called a court or bench trial, meaning it would be the judge instead of the jury who would hear the evidence, apply the law, and decide whether or not the state proved your guilt. You understand that? Constitution, Mr. Frederick, you have a right to use confront witnesses against you and have your attorney cross-examine in open court. So what that means is the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else is present. After the prosecutor then asks you questions, your attorney asks questions, that's called cross-examination. The purpose of that is bring out evidence to help your side of the case. You understand that? Under the Constitution, you have a right to use the power of the court to compel or force witnesses to come to court and testify on your behalf to the state. Now, what that means is that if you have witnesses you're not certain going to bring in voluntarily, request the court will issue a court order called subpoena, and forces those people to come to court to be able to testify if they want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come to court and testify against you. You understand that? And under the Constitution, you have privilege of self-determination. You cannot be forced to give evidence in this matter at any time before the trial. No one ever can testify. The prosecutor can't, the judge can't, it's your decision. You decide not to testify. The fact that you did not testify, not be used against you in any way, or any person at any time, no one is even allowed to talk about it except in one situation. That is, if there is a jury trial, you do not testify. The judge instructs the jury that because that's your right, they cannot consider it for any purpose. And that. Right, under the Constitution, you're presumed innocent until proved guilty by the state of every essential element of the offense. What that means is that you cannot be forced to evidence or testify in this matter at any time before your trial. No one ever can testify. The prosecutor can't, the judge can't, you make a decision. If you decide not to testify, the fact that you did not testify, not be used against you in any way or any person at any time, no one's even allowed to comment about it except in one situation, that is if there's a jury trial about to testify. The judge instructs the jury that because that's your right, they cannot consider it for any purpose. Understand that? The Constitution, you are presumed innocent until proved guilty by the state of Ohio of every essential element of the offense charge. So what that means is that the burden of proof is on you to try to prove you're not guilty, simply because you're accused. In fact, under the law, you don't have to put on any evidence at all at trial. You may not, but you may, which not requires it. Whether you do or not, the burden of proof will remain upon the state to prove guilt, prove beyond reasonable doubt, every essential element of the offense charge, which is the highest burden of proof is known under the law. You understand that? Now, originally you pleaded not guilty. Not guilty plea denied the allegation in the indictment, not committed any crime. and exercise or invoke all the rights I just described. If you change your plea from not guilty to guilty, that is the opposite of not guilty plea. The guilty plea admits the allegations in the indictment, admits that they constitute a crime, that you committed that crime. That plea waives gives up all the rights I just described to you today, except for the right to have an attorney, which you always have, no matter what you plead. That exception, you plead guilty, the way you give up. The right to a jury court trial, the way you give up, the right to front witness against you, cross-examine for your attorney, the way you give up, the right to use power court, power force with the Supreme Court, testify to you the same as the state. The way you give up your privilege and self-determination, because if you say you're guilty, that's what you find you guilty. The way you give up your presumption of innocence, if you say you're guilty, the state doesn't have to prove you guilty. Also subjects you to being sentenced to being in court, finally gives up waives your right to file an appeal and alleged violations of the rights you feel could have occurred up to this point in the case. Now, since an active sentence, under other circumstances, you file an appeal, that would have to be filed within 30 days of sentencing interview file. You understand all that? And are you a U.S. citizen? Right now, do you have any questions about the charge and possible penalty? You understand it? You have any questions about the plea agreement? You understand it? Any questions about the constitutional rights of the claim? You understand them? Any questions about the plea of guilty, what it means, what will happen? You enter that plea here today. Now, is there anything you'd like to speak with your attorney about before we go any further? So I wish you heard the breakdown. You don't need to? You have any questions about anything that I've explained? And this is your decision to withdraw or not guilty, plead guilty to the charge, pursuant to count 1, pursuant to the terms of the agreement. And as to the charge of count 1, which alleges that on or about June 17, 2021 in Huntington County, Ohio, she did knowingly sell, offer, sell methamphetamine, a Schedule II controlled substance amount equal to or exceeding bulk amount less than 5 times bulk amount. Violation of section 2945.8381, third degree felony, and possible prison term from 9 to 36 months, fine of $10,000, mandatory fine of $5,000, possible license suspension 6 months to 5 years. How do you plead? How do you plead? Court finds on this date of the court, defendants advise all the constitutional rights made no intelligent, voluntary, way of the same, pursuant to Rule 11, Pleas 705. Defendants found guilty of count 1, count 2 dismissed. Court order pre-sentence investigation of the same bond with an assessment for substance abuse disorder treatment and mental health. Sentencing will be set for July 6th at 9 a.m. All right, anything further, counsel? All right, thank you. All right, I believe that's our last Zoom here.
Yes, sir.
All right, so I think you have a couple clients over here as well. All right, Leona Reinhardt. Case number 22-0125, State of Ohio versus Leona Reinhardt. Present for the state, Prosecutor King. Present behalf of the defendant, Attorney Kirk. Are you, Leona Reinhardt?
Yes, sir.
All right. The defendant is charged with 2 counts of aggravated trafficking and that 2 counts of aggravated possession. This is the first pre-trial, not pre-trial sentence, June 2, trial sentence July 11. See, the state provided discovery in adult particulars. Is your discovery of the project?
Not yet, Your Honor.
All right, so we've got a file pre-trial, any pre-trial motion,
Not at this time.
and a written plea offer provided. Yes.
There has not really been one.
All right. Any other matters being discussed this time?
No, Your Honor.
Something in this original bond out there, loose the bond. All right, we'll see you back here, 22nd, you know, thank you, sir.
Yes.
Yeah, all right, so you're on pre-trial, my name. Dustin, read. Case number 22 CR 07. State Myers Dustin Green. Attorney on behalf of the state, the property of King. We have the defendant, Attorney Kurt, review Dustin Green.
Yes, Your Honor.
Green charged with assault on a peace officer at 4th Street felony. I think we have a trial date now. The trial date, I believe, has to be 37 to 41st.
I don't believe we have any new dates yet, Your Honor. Things were stayed because of the evaluation.
Oh, well, in this case, it's probably an act copy, so I actually don't have anything
We do have the evaluations back.
to do. Oh, we did?
Yeah, I believe it's set for that.
Okay. I don't have that.
I'll be a judge.
Yeah, well, before you do, let's take an application for you on that.
Okay.
Dustin Conlon, Dustin Conlon, I should say. That's why I should get that. Alright, case number 22 CR 116, State of Ohio versus Justin Conley. From the state's, King, but we have a defendant, Attorney Nick Wagner, your Justin Conley. Conley charged, in an 8-count indictment, total 11 he charged counts 1 through 8 with various aggravated trafficking and aggravated possession of drug cases. This is a pre-trial. First trial. Yeah, first pre-trial. One pre-trial, 2.2. Trial date was July 14th. Alright. I believe that I saw that there had been discovery provided. See. You filed your discovery yet?
I think we did, Your Honor. I think we did it yesterday.
Yeah, I'll put that out, check.
Maybe today. Don't quote me.
Well, do by file pre-trial, right?
Yes, sir.
Anticipated pre-trial motion,
Not at this time, Your Honor.
has been written over, provided.
Yes. And we've gone over it. Just if I may, sir,
Yes, ma'am.
I may, depending on the court's docket, my case of my client, he originally was in, I think he followed it out, that's why it's been fast tracked. The next pre-trial we may slow it down for court's permission, Your Honor.
Okay. All right, any other matters we need to discuss?
No, Your Honor.
All right. And see you next pre-trial.
Stay in contact. Good to go.
All right, Sarah, Cole Wilson. Case number 22 CR 127, State of Ohio versus Sierra Cole Wilson, the state prosecutor King, on behalf of the defendant, is Jake Wagner, your Sierra Cole Wilson.
Yes, Your Honor.
All right, Ms. Wilson is indicted in a second count indictment on Mr. Wilson for aggravated trafficking and aggravated possession, methamphetamine and forfeiture. This is the first pre-trial, and the pre-trial, I think, set for second one here. And trial date. Set for July 11th. All right, now I see that, I see discovery in this file.
We got it, May 12th, Your Honor.
Alright, look there. Oh, here it is. So much to talk about that for a little, alright. Yeah, you see, we provide discovery, they did, and, we provide yours yet.
Yeah, I came over with Mr. Collins, Your Honor.
Okay. Anticipating a pre-trial motion.
No, sir.
Has been a written plea offer provided.
It has and related.
Alright, other matters we need to discuss at this time.
No, sir, Your Honor.
Alright, see you back on the set as well as the bank.
Stay in contact. All right, keep checking with probation.
See who else we got.
Well, I've been informally retained by Miss Workman, but she has on shorts.
Yeah, and by the way, that's the third defendant showed up today in shorts, which means that people must take on getting forgetful of old age, but the rule's been there for 14 years, they're And, what, just for everybody's benefit, the next person shows up here in shorts, it's on your notices, it's posted right outside, they show up in shorts. The whole national council asked for it.
Yes,
I'm
sir.
not tired of dealing with it.
Yes,
Not
sir.
reading or not paying attention. And one guy, among other things, today, they were in jail, not for that, but it was part of it, because it is that wasn't reporting information, wasn't, treatment, and a number of other things, so I had to get his attention. So, people, listen to what I say, do what I say, and for consequences will be, so. All right, so for her, we continued, you're entering her parents' are going
No,
to.
I will file a formal notice of appearance. I think Ms. Hillier has indicated they continue it maybe 1 week.
Okay.
But yeah, I'll file a notice of appearance at discovery.
All right. All right.
Thank you, sir.
Mr. Kirk, we're ready now on, grade. Alright. We're back on record, case number 22 CR 7, state of Myers, that's next read. As Mr. Kirk noted, he referred for a examination, and the court did receive that. Actually, we recently, I didn't recall dating this one, but now that you say it, we had it. I read it at the time, but I don't have any recollection. Yes, each of the attorneys received a report, copy of the report. State that anymore.
We have, Your Honor.
Alright, and let's see. That report was done by Dr. Kurzals, Robert Kurzals, Kurzhals, PhD, May 9th. Date of his report was May 23rd. And his conclusion was that defendant does not suffer from a severe mental defect. The signs of severe cognitive impairment. He's not suffering active symptoms of severe mental illness, and therefore he's capable of understanding the major objective proceedings and able to assist counsel, and so his recommendation be found upon. Now, either parties wish to submit any additional evidence. Nothing to say.
Nothing from the defense, Your Honor.
Right. And the court will find that he is not going to stand trial. I also note that I ordered a evaluation for issue of time of alleged offense, and there's no basis for filing a, I believe, insanity. So that will be restored to the active docket. Set a final pre-trial. June 22nd at 2 p.m. Trial will be July 14th, 8 a.m. All right. Anything else that we discussed this time?
Regularly, Your Honor.
All right. You get your sign notice over here, if you agree to keep in contact with your attorney.
All right, thank you, Your
Are
Honor.
you in treatment this time?
I'm sorry.
Are you in any kind of treatment at this point?
I'm there. They want me to get an assessment through Braille.
Right, because I see you tested positive, the 19th, was the last report I have. So, you can go get assessed, because that's condition of fail. That recommended for the assessment that you do it, and the treatment indicated you need some minute drugs that I saw over that screen. I suspect you.
Thank you.
Ryan Wilson. case number 22, CR 126, State of Ohio versus Ryan Wilson. Ryan L. Wilson. Present on behalf of the state is Prosecutor King, and defendant is Attorney Hacker. You are Ryan L. Wilson.
Yes, Your Honor.
Wilson charged on the Sierra Wilson in a 7-count indictment, 3 counts of aggravated trafficking, 3 counts of aggravated possession of methamphetamine and a forfeiture. This is a first pre-trial, and the final pre-trial set on the 22nd, and the trial is set to the 11th. See, the prosecutor did file a line of discovery and a bill of particulars. See where we have this happening.
Yes, I filed my compliance on May 13th.
Oh, did that on that day too?
Yes, apparently it was a big day for me, but not a big day for the clerk's office.
It's always great if you did something that you don't prepare for instead of not doing something.
Exactly. Exactly.
Okay, well, there it is. Okay. 13, all right. Did you submit a pre-trial motion?
Not at this point, Your Honor.
And it's been a written plea offer provided?
There has, and I have given a copy of that plea offer to my client.
All right, are there any other matters that need to be discussed at this time?
No, Your Honor.
All right, thank you. Carl Hatfield?
My approach, Your Honor.
Right. All right, case number 22 CR 87, State of Ohio versus Carl Eugene Hatfield. President of the state is Assistant Prosecutor King, President of the defendant, Attorney Witt. Are you Carl Eugene Hatfield?
Yes.
All right, Mr. Hatfield was charged on Melvin McKenzie in 8-count indictment. Various aggravated trafficking and aggravated possession have been charged. This is a final pre-trial, and we have a trial date of June 16th. Now, I've been presented with a guilty form, Mr. Hatfield, which indicates you're going to withdraw your ongoing guilty to counts 1 and 3. This is a 3-page form. On page 3, there's signature lines, and halfway down there's a sentence that says, I entered the plea voluntarily. I believe that people below that there's a signature, what I believe to be Carl Atkins. Is that your signature looking at?
Yeah.
And when did you sign this agreement with Hatfield?
5 years today.
All right. And did you go up with your attorney before signing it? And did you understand it's an agreement to plead guilty, which means it's not going to be a trial? The next step in your case will be a sentencing hearing?
Yes.
And is this something you thought might occur when you came here today?
Not really, but it's
So you feel you've got enough time to fully consider the matter before making this decision? You're not rushed or pressured in any way? And speak up a little bit, so make sure we get your voice. All right. Are you entering into the agreement to plead guilty voluntarily?
yes, Your Honor.
Now, the agreement states on page 3, page 1. You're going to withdraw your not guilty plead guilty to count 1 and 3. Count 1 being aggravated trafficking, methamphetamine, and count 3 being aggravated trafficking, methamphetamine in school. Both are violations of section 2925.381. Count 1 is a 4th-degree felony carrying off a prison term conviction between 6 and 18 months, $5,000, and it costs a license suspension 6.5 years. Count 3 is a 3rd-degree felony carrying a possible prison term between 9 and 36 months, on $10,000, mandatory fine $5,000, and a possible life suspension of 6 months to 5 years. You understand all that?
Yes, Your Honor.
Now, under the law, if you are convicted of both offenses, that's free. Sentences will be ordered to be served consecutively, meaning one after the other. That means it's possible maximum penalty would be 54 months in prison, possible fine of $15,000, mandatory fine of $5,000, and life suspension of 6 months to 5 years. You understand that?
Yes, Your Honor.
Other than these charges, are you facing any felony charges in any other jurisdiction?
No, Your Honor.
Are you currently on probation, community control, parole, social release control, or any jurisdiction?
No, Your Honor.
Under the law, Mr. Hatfield, you're convicted of these offenses and sentenced to prison. Once you impose the plea term imposed by the court, the adult parole authority has the option under the law to place you under post-release control supervision for a period of up to 2 years. They don't have to, but they could, it's up to them. If you violated those conditions, they can return to prison, and you can serve an additional period, that's set by the court, about 9 months for a single violation, but there's a cap limit of half of the prison term that you receive for all violations. However, if you are convicted of a felony on post-release control supervision, then an additional penalty will be imposed, sentence will be imposed by the judge in that case. That judge will also have the authority to sentence you to an additional period of 1 year, whatever time is left on the period of 2 years post-release control, whichever is greater, for committing that offense or other post-release control in this case. You understand that?
Yes, Your Honor.
All right, now, under the law, not required to sentence you to prison for offense, can impose what's called post-release or probation or community control. That means that instead of being sent to prison, you would be put with a supervision probation officer for a period of up to 5 years. During that period of time, the probation department felt that you were not compliant, and they would file a written notice of that report, serve a copy on you, and there would be a hearing. You would not be represented by an attorney at that hearing. If the outcome of that hearing was that you failed to comply, but at that time, the court would revoke your community control, then sentence you 54 months to prison, fine you $15,000. You understand that?
Yes, Your Honor.
That one alleges that on or about March 25, 2021, Miami County, Ohio, it's you and Michael McKenzie did knowingly sell or offer methamphetamine schedule 2 controlled substance, violation section 2925.03. So that's aggravated trafficking methamphetamine for with a penalty of between 6 and 18 months imprisonment, fine $5,000, and a possible license suspension of 6 months to 5 years. Count 3 alleges on about May 28, 2021, Miami County, Ohio, that you and Michael McKenzie did knowingly sell or offer methamphetamine schedule 2 controlled substance in juvenile. Also violation section 2925.03. That charge is a third-degree felony, very possible prison term of between 9 and 36 months, upon $10,000, mandatory fine of $5,000, and a possible license suspension 6 months to 5 years. Now, you understand what it is you've been charged with in this 2 counts, what the state said it did, when or how it alleged it?
Yeah.
Have you discussed the nature of the charges, the evidence in the case, possible legal issues in the case, possible offenses by preparation trial, possible outcomes of the trial with your attorney? Are you satisfied with your advice and confidence in the matter? Are you under the influence of any types of drugs or alcohol at this time?
No.
Are you taking any prescription drugs?
No.
Have any threats been made against you to plead guilty here today?
No.
Has any threats been made to make you plead guilty?
No.
Now, on page 2 at the bottom, there are 3 sentences that are printed in bold and underlined. Read as follows. Finish on plead guilty to counts 1 and 3. State will dismiss the remaining counts. State will not oppose community control, residential treatment. Finish on make full restitution. Finish on cooperate fully with the task force. Is that your understanding of the agreement?
Yes, Your Honor.
Does anyone promise you anything other than that to get you to plead guilty here today?
No, Your Honor.
Under the law, the recommendation of sentencing is not binding on the judge. So even though the state is not opposed to community control, there is no guarantee that you'll get that. So if you plead guilty, I don't have to give you community control. On the good side, you should be sentenced to prison for up to 4 months, fine fine with $50,000, $5,000 mandatory fine, and license suspension 6 months to 5 years. You understand that?
Yeah.
All right, now do you hold any license or certification from any state governmental agency that regulates, governs any occupation or profession? And you have certain constitutional rights. You must understand before I accept the plea, first you have the right to have an attorney. This witness appointed represents you. That wasn't simply to work the case out, but to provide any defense could be available under the law which are provided. So, if you decide you don't want to plead guilty, that you want to defend against these charges, she'll continue to represent you and defend you, including a trial, if that's what you want. You understand that?
Yeah.
Now, under the Constitution, you have a right to have a jury trial on these 2 charges, which means that a jury of 12 people be selected from a group of citizens that live in Hyman County, summons for jury duty on your trial. After they are selected, the evidence will be presented and they will be instructed on the law. Then they will decide by unanimous verdict, between 12 of all have to agree as to whether there was a verdict with either count. Now, if you decided you didn't want to have jury trials, you didn't want to plead guilty, you can waive in writing, which means give up the right to have jury trial. In that case, you would have to hold a court or bench trial. What that means is that instead of a jury hearing the evidence, the judge will hear the evidence, the judge will apply the law, the judge will decide whether or not the state proves your guilt. You understand that?
Yeah.
Now, under the Constitution, you have a right to front witness against you in open court and cross-examine your attorney. What that means is that the witness against you have to come into court, testify in front of you, your attorney, and anyone else in the present. The prosecutor is going to ask you questions, your attorney asks questions, that's called cross-examination. The purpose of that, trying to bring out evidence that will help your side of the case. You understand that?
Yes.
Right, under the Constitution, you have a right to use the power of the court to tell force witnesses to come to court and testify for you, just like the state. So if you have witnesses you're not certain whether to voluntarily, to request or release your court order less a subpoena, that forces those people to come to court to testify on your behalf, which is the same way the state's witnesses are forced to testify against you. You understand that?
Yes.
Right, under the Constitution, you have a privilege of self-incrimination. It means you cannot be forced to give evidence in this matter at any time, including trial. No one's ever in possession. The prosecutor can't, the judge can't, you make a decision. If you decide not to testify, the fact that you did not testify, not be used against you in any way by any person, no one's even on comment about it, except on the situation. That is, if there's a jury trial, you won't testify. The judge instructs the jury that because that is your right, they cannot consider it for any purpose. You understand that?
Yes.
Right, under the Constitution, you presume innocent of these charges to prove guilty by the state of Ohio, and every essential element of each offense, that means that the burden of proof is on you to try to prove you're not guilty simply because you're accused of this crime. In fact, in the law, you don't have to call any defense at all. You may, but you're not required. Whether you do or not, the burden of proof will be on the state. Prove your guilt, prove beyond a reasonable doubt each of the offenses charged, which is the highest burden of proof is known under the law. You understand that? Now, originally, in her plea not guilty to these charges, Mr. Hatfield had pleaded 9 allegations. In each count, I committed a crime, and it exercised all the rights of Mr. Stratton. You change your plea from not guilty to guilty, that's a plea off the law. You only plead admits allegations in the indictment, commits a third crime, she committed the crime. That plea waives gives up all the rights that are just described for you, except the right to have an attorney. So the right to have an attorney no matter what you plead. That exception, plead guilty, waive give up the right to use your court trial, waive give up the right to confront this issue, cross-examine through your attorney, waive give up the right to use the power of court, compel a forceful discussion court, that's my attorney absence of the state, waive give up the privileges of self-incrimination, but you're not saying you're guilty, that's what she's applying guilty, and waive give up the presumption of innocence, but you say you're guilty, the state doesn't have to prove it. Also subject you to be sentenced immediately by the court. And finally, if waive gives up any right to file an appeal, then you may have had up to this point in the case. Now, if I should sentence you back to sentence, so that certain circumstances, you could file an appeal. That appeal would have to be filed within 30 days. Your sentencing after would be filed. Understand all that?
Yes.
And are you a U.S. citizen, Mr. Hatfield?
Yes.
Now, do you have any questions about either the charges or the possible penalties?
No.
You understand?
Yes.
Do you have any questions about the plea agreement? Understand? Again, you understand the recommendation as to sentence isn't binding on the judge. Have any questions about constitutional rights I've explained? Understand those? Have any questions about the plea of guilty, what it means, or what will happen if you go to that plea here today? Is there anything you'd like to speak to the attorney about before we go any further? This is your decision, Mr. Hatfield, to withdraw your not guilty plea. And counts 1 and 3 plead guilty in accordance with this plea agreement we just went over. Is it your desire to go forward and plead guilty counts 1 and 3 according to the plea agreement? Then as to count 1, which alleges that on or about March 25, 2021, Highland County, Ohio, Jew, Melvin Michael McKenzie, did knowingly sell rock and sell methamphetamine, Schedule 2 controlled substance violation, Section 2925.03A1, charged with aggravated trafficking methamphetamine, carrying possible prison term as a 4th-degree felony, 6 to 18 months, fine $5,000, license suspended 6 months to 5 years, and plea. As to count 3, which alleges that on or about May 28, 2021, in Highland County, Ohio, you and Malcolm McKenzie, Michael McKenzie, did knowingly sell rock and sell methamphetamine, Schedule 2 controlled substance in the vicinity of juvenile, violation section 2925.03A1, which is a 3rd-degree felony, carries a possible prison term between 9 and 36 months, fine of $10,000, and further fine of $5,000, and possible license suspension 6 months to 5 years. Okay. Court advised on this day, open court, defendant advised all constitutional right to make going telephone calls carried away with the same percentage per month. Please accept the order filed, defendant found guilty of counts 1 and 3. Counts 2. All the remaining counts are court will refer the matter to the probation department at the same bond. Including a report as to substance disorder and mental health assessment. Next will be July 6th at 9 a.m. All right, is that any further counsel? All right, they go down to probation to set up a pre-sentence investigation, interviews as we get out here. After you get your time, those mail over the other day will be off. All right, thank you. William Penix. I see it there, Penix. Have 2 cases here. Well, we're saying that case number 22-97, 22-11, over state of Ohio, including Penix. Representing the state is Justice Prosecutor King, you are William Penix.
Yes, sir.
All right, Mr. Penix, you had indicated you wanted to hire an attorney, and so far we've not heard from any attorney. What's the situation?
Me and Balder entered into talks, could come to an agreement, so as of yesterday, I employed James Chandler of Beaver, Ohio.
Where?
Beaver, Ohio.
You employed him?
Yes, sir. Paid in full. Thought he could get hold of your office and let you guys know something.
You contacted him yesterday?
Yeah, I went to his house and.
Have you heard from Mr. Chandler?
James Chandler.
Well, today's the final pre-trial, the first case, and your trial is set for 27th, and the other case, maybe the same day, so actually set for the 14th live trial now. So, we need to get back over to Mr. Chandler, trying to get his parent trial all the way to the last minute, because that's 4 weeks. And that case is hanging around out the table. 2 months to, nearly 2 months to get the term. So he just prepares a case so we can get him on the docket and contact us about what's going on.
He said yesterday when I left his house after I paid him, he gave me a receipt that if he didn't get in contact with you guys today, that this week he's coming to my house to pick me up, he's coming up here to do something. I don't know what he was planning.
Why you wanna come pick you up, that's included, but, you know, if he needs to talk to you about a case, that's fine, but, you know, well, he needs an entry appearance, so we can expect him to be here, you can tell him, we got probably 4 weeks, or less than 4 weeks, 26 days.
Yes,
So we better either get something filed or, you know, be prepared to go to trial that day.
I'll call him soon as I
All right,
get
make sure you stay in touch with the probation department.
Please rise.
All right, like I said.